Hello friends, Namaskaram. Today I am going to discuss an important topic under Prevention of Corruption Act. The judgment is based on technical approach of Honorable Rajasthan High Court. Got the point now? In which the benefit of Section 17A of Prevention of Corruption Act had been given to him. Judgment is titled as Rani Dan Singh versus State. Judgment has been pronounced by Honorable Rajasthan High Court on 8th of October 2024. In that case, there are two petitioners. One is CI and other is ASI. Both had been appointed and discharging function at PS Ganga Shahar, Bikaner. You got the point? The allegation of consent complainant and the agency is that they committed the crime under Prevention of Corruption Act, and that's why both of them had been prosecuted under Section 7 of Prevention of Corruption Act, and also FIR has been registered. In the meanwhile, they submitted a petition for quashing before the Honorable Rajasthan High Court. It has been accepted. So we have to understand what is the success story of these two persons and how they could avail the benefit of Section 17A of Prevention of Corruption Act. As we know that the benefit of that section could not be given in a corruption case. Despite of that, there is a demand, but they got the benefit and ultimately got discharged, and proceeding had been quashed by the concerned High Court. So to understand the same, we have to capture certain facts which are quite important. Fact number 1. They submitted to the court that we are having 5 uncontroverted facts which are required to be noted, and these facts are quite important for disposal of the present petition. Fact number 1, we are public servant and we are assigned with the public function, and being the police officials, certain persons had come to us that a cheating has been committed in the competitive exam. We had examined the entire scenario, and after that we have lost the FIR. So we are bound by direction of Honorable Supreme Court, which said that in cognizable offence FIR is required to be registered. So we have discharged the official function. Got the point now? Now it is easier. And after that, it is required that the proper matter is to be investigated. So for this, Mr. J, who is ASI, has been appointed, and during the course of investigation he found that a firm named as Prithviraj Enterprises Delhi had been involved in the alleged crime. So to make the proper investigation, he visited that place and he found that complainant, who is the owner of that institution, inter alia indulged in the said crime. And after that, electronic devices, certain amount of money had been seized, the description of which is 1,02,000 rupees, 2 mobile phone, 3 CPU, 2 laptop and 1 DVR. And they had been tagged as illegal devices used in the alleged crime of cheating in the competitive examination. And finally, the concerned accused, means the complainant of present case, and the concerned article had been brought to the concerned PS of Bikaner. It is an allegation of the concerned complainant that after that concerned CI interrogated him, he has used the third degree treatment, he has beaten him and further threatened him that if rupees 5 lakh is not given, then the complainant has to bear the serious consequences, and ultimately his life would be vanished. And ultimately he reported the matter to the concerned ACB official. In the meanwhile, it is an allegation of the concerned complainant that the belonging of him is not given to him. He made certain requests, but it is not given to him. Only certain articles has been given, but certain article had been retained by concerned CI in the illegal manner. They have submitted that. Point number 2 is that when the concerned recording had come into the kind knowledge of the concerned CI, the CI apprehended the concerned complainant. Inter alia, he took the digital voice recorder and compelled him to sit and threatened that if he rescue or inter alia tried his best to go outside, then he would be arrested. And in the meanwhile, the concerned CI left the PS with that voice recorder, mobile phone, CPU and power bank that has been illegally written by him, so that the valuable evidence could be destroyed. In the meanwhile, the concerned ACB official had communicated with the complainant and he informed him about the same, and that's why a report has been lodged by that official that certain articles which are the valuable property of the case had been taken away by the concerned CI. In that case also, FR had been given and case is found false. And apart from that, the concerned ACB inter alia lodged the FIR on the ground that the concerned complainant, while having a meeting with one of the official of the concerned ACB, submitted a pen drive voice recorder with the submission that all the incident had been recorded in the same, and in the meanwhile on that point demand had been verified and FIR has been lodged. While assigning the same, they submitted that the demand is not verified because the private device has been used, and using the private device itself not permissible. And apart from that, voice recorder, its source, authentication, whether it has been stolen or not, is not proved, and inter alia, the point of theft is found to be false by the concerned investigating agency to whom the matter has been reported that the voice recorder of ACB has been stolen. Okay, now got the point now. Point number 3 is that Section 17A of the Prevention of Corruption Act is quite imperative in the case because it submitted that while doing the inquiry or investigation against a public servant in connection with the act concerned with his official function, the prior approval of department is going on. In such case, it is fact that the concerned official investigated the case and while doing the investigation they had demanded the money. So entire scenario of crime is concerned or connected with their official duty. So when the things are connected and concerned with their official duty, benefit of section 17A of PC Act would be given. Even the court has submitted the example in the judgment. If the concerned work is not concerned with the official function, in that scenario benefit could not be given, but if it is concerned then benefit could be given. Okay na? So that is very important point. Point number 4, they have relied on judgment of Yashwant Sinha versus CBI. In that case, even Honorable Supreme Court submitted that the said section is imperative in nature, means mandatory, and deprivation to accuse regarding the benefit of such section would amount to mockery of justice or miscarriage of justice. That's why they submitted that entire protocols are mandatory, but the concerned SCB has not shown any concern regarding the same. And number 5th point is that the court is having the ample power to quash the proceeding if no case is made out or case made out, but the procedure adopted by the concerned officials are abuse of process of law. And as we know that in such matter, state of Haryana versus Bhajanlal usually relied by the concerned defense to have the quashing in the matters. So court, by looking into the facts and circumstances, concluded that number 1, it is fact that there is no acceptance and recovery from the accused persons. Number 2, that the case is based on demand, and if demand is there, it should be specific and must be concerned with the abuse of official powers misuse. If there is no other evidence, in that scenario the accused could not be connected. Number 3, section 17A of PC Act is imperative. If the alleged act is concerned with the official function and the allegation is pertinent to the same, in that scenario benefit of section 17A of PC Act could be given. If not given, it will amount to mockery of justice. Number 4, the pendency of work, other scenarios, motive are the quite important factor to be determined while adjudicating the case of the concerned accused on merits and even technical issues, if we are going to provide him the benefit of section 17A of the PC Act. Apart from that, the court specified that the entire allegations are not supported by any evidences. If section 17A benefit is not given, in that scenario, it would result in mockery of justice, involvement of innocent public servant in the crime, and which is not the intent of criminal jurisprudence and the criminal law of our country. So looking to the facts and circumstances, the benefit is given. So this judgment inter alia provide us the 5 ways to get rid from the corruption case if we are having the same issue. If the FIR is lost, just read it. If there is no demand and there is no acceptance, you may go to questioning. Number 2, if there is demand but no acceptance, in that scenario you have to identify whether the demand is connected with your official function or not. If it is connected and it is basically a demand case, then we could avail benefit of section 17A of PC Act. Number 3, the judgment of Yashwant Sinha versus CBI is of Supreme Court. Judgment is quite important and the benefit of such judgment could be availed by us. Number 4, all the provision of section 17A of PC Act, if not considered by the concerned investigating authority, in that scenario we could submit the representation or memorandum to avail the further benefit, because before moving to the concerned High Court, we are requiring a cause of action. So cause of action comes to motion when we make a submission and they fail to consider. And number 5, we are required to submit to the concerned authority the points which are technical in nature. If technical points are not considered by them and they are not giving us the benefit of law which is in our favor, in that scenario the remedy is to move before the Honorable High Court under the questioning proceeding. So these are the important points for you. If you are having the same trouble, then you could easily avail the benefit of these citations. So see you in the next video. Till then, Jai Hind, Jai Bharat.